Hi everybody, welcome to the 8th video for Legal Studies 3-4. In today's video, we're going to be covering bicameralism, separation of powers, express rights, the High Court, and the double majority principle. To start off with, we're going to be looking at bicameralism, which touches on what we learned in the last video, which outlined that the structure of Parliament comprises of two houses, a lower and upper house. And we spoke about how the upper house is designed to act as a house of review. And so this touches further on that. So bicameralism is just a fancy word of saying two houses. So the structure of our parliament has a lower and upper house, as we already know. And the purpose of that is to ensure that there's a second house to act as a check on the house which is introducing the legislation to parliament. And so because, as we spoke about in the first video, because government is formed in the lower house, most of the bills are introduced by the lower house. And so that means that usually the Senate or the Legislative Council acts as a house of review. This means that the second house can identify any errors, injustices, or mistakes that are in the proposed legislation by government. This also allows for genuine debate, and it ensures that a wide range of opinions are considered. So for Commonwealth Parliament, it ensures that the people's interests are being considered by the House of Reps and the state's interests are also being considered by the Senate. And that it ensures that the upper house can provide amendments and scrutinise the understanding of the proposed bill. However, the ability of the purposes of bicameralism to be achieved depends on the composition of the second house. So if government holds a majority in both the upper and the lower house, then the upper house may not actually provide for that debate and scrutiny, and may instead act as what we call a rubber stamp, which is where the members of the second house, usually the Senate, will just vote along party lines without any debate. So if the government, if let's say the Liberal Party holds a majority in the lower and the upper house, and the Liberal lower house proposes a bill, then the senators who are holding the majority, the Liberal Party, will just approve the bill because it's a Liberal policy, rather than actually scrutinising it and proposing amendments and changes to that bill. This allows for more laws to be passed and, essentially upholds the purpose of Parliament to create laws, but it doesn't allow for serious debate and scrutiny, and it may mean that not enough opinions are being considered. The principle of bicameralism is also protected as it is specifically stated in Section 1 of the Constitution, which outlines there must be two houses of Parliament. And that means that it cannot be changed. The only way it can be changed and removed is by referendum. So Parliament could not just remove the upper house if they wanted to. Furthermore, if government did not hold a majority of seats in the upper house, so we had a Liberal lower house and a Labor upper house, then that may allow for more debate and scrutiny, as we call this a hostile upper house, because the upper house doesn't want the legislation of the government to necessarily succeed. And so that allows for a wide range of political opinions to be considered, but it may prevent the legislation being passed, and it may prevent the ability of Parliament to achieve its main aim of passing laws. Furthermore, there is no requirement for bicameralism at state level. So, for example, Queensland abolished their upper house in 1922, so it's considered unicameral. The next thing that we need to look at is the separation of powers. So the separation of powers outlines the three branches of government: the courts, government, and parliament, and outlines that each must be entirely independent from one another. So the main purpose of this is to ensure that no single branch has absolute control over our political and legal functions, and that no single body can create, administer, and then enforce the laws. And essentially, it ensures that democracy is upheld and we do not become a dictatorship with a political party which holds absolute power. So the first branch of government that you need to know is the executive. So the executive is outlined in section 61 of the Constitution, and the executive is essentially the government. So it's the head of the executive is the Governor General, and they then appoint the Prime Minister and the ministers who make up the executive. And the role of the executive is to administer the laws and carry out the functions of government. So if Parliament created a law which said that there needs to be a hospital built in every suburb in Australia, then the government would be the one who is responsible for actually ensuring that those hospitals are built, for example. So they're administering and carrying out the laws. The next type of branch of government is our legislative. So the legislative is essentially Parliament, and they are outlined in section 61 of section 1 of the Constitution. And so legislative powers are vested in the federal Parliament, both our upper and lower house, and the main role of the legislative is to create laws. The third branch of government is the judiciary. So the judiciary is outlined in section 75 and section 71 of the Constitution, and the judicial power is vested in the courts. And that outlines the power to enforce and interpret the law and settle disputes. The separation of powers is very important because, as we spoke about before, it protects democracy in Australia and protects our human rights, because one branch of government does not have absolute power and cannot take away our human rights if they wanted to. There's those two other branches which act as a check and balance on one another. So, for example, the executive scrutinises the legislative in Parliament, and the legislative scrutinises the executive in the upper house, and the judiciary scrutinises both through courts. Another strength of the separation of judicial powers is that the judges are not influenced by political grounds and political concerns. So that is upheld through the elements of fair trial that we learned about in the first area study. So things like having a fair trial with an impartial judge and having public confidence and public hearings. Another strength of the separation of powers is that the judges have tenure. So judges have a secured position until they are 70, so they cannot be fired because of a judicial decision. What that means is that judges are not worried about making decisions which are not in Parliament's interests because they can't lose their job. The separation of powers is also entrenched in the Constitution, so outlined in section 1, section 61, and section 71. And what that means is that Parliament could not remove the separation of powers if it wanted. The only way would be through a referendum put to the people, and it's very unlikely that that would ever succeed. However, the separation of powers is less effective due to the overlap between the executive and the legislative. So the Governor General is the head of the executive, but they also sit in the legislative and approve the Parliament's legislation by providing royal assent. Furthermore, the Prime Minister and the Minister are the part of the government, part of the executive, but they also sit in Parliament in the lower house. So there's a massive overlap between these two branches. Further, as we spoke about in relation to bicameralism, if government holds a majority in both seats, then the Senate has less ability to scrutinise the executive. So the legislative is going to provide less debate and scrutiny of the legislative's policies. Also, the fact that judges can be appointed by the executive, so that can be seen as judges influencing the executive influencing judicial decisions. So the executive may appoint more conservative judges or more activist judges to try and sway the decisions of cases. And furthermore, the separation of powers is not mandatory for states. An example of the separation of powers is the Commonwealth and Besim. So in the Supreme Court, there were 2 terrorism charges which were on appeal, and the judge had not yet handed down a verdict. While the verdict was being handed down, 3 federal ministers made comments stating that the Victorian Supreme Court was too lenient on terrorism and was more concerned for the terrorist welfare than for the victims. And so the Court of Appeal was critical of these statements and outlined that they breached the separation of powers. And so the ministers were forced to apologize, or otherwise they were threatened with being held in contempt of court, because it was seen as them, influencing the decision of the judge to try and, advocate for a harsher sentence for the convicted accused in that case. The next check on Parliament is our express rights. So we have 5 express rights that are listed in the Australian Constitution, and they are enumerated and entrenched. So what that means is that they are written in the Constitution and can only be therefore removed by referendum. So the express rights acts as a limitation on Commonwealth Parliament, because Commonwealth Parliament cannot make laws which infringe upon these rights. Unlike the US, we don't have a Bill of Rights. So these are the only 5 rights which are listed in our Constitution. The first right is outlined in section 116, and it outlines the right to freedom of religion. So the Commonwealth cannot impose a state religion in Australia or force any form of religious ceremony or worship. The next right is the right to free interstate trade and commerce, which outlines in section 92. And what that ensures that there's no unfair taxes between states. So if you want to import sugar cane from Queensland, there's no unfair tax on that for Victorians. The third right is the right to receive just terms when your property is acquired by the Commonwealth. This is outlined in section 51. And so what this right outlines is that if the Commonwealth Parliament was wanting to purchase your property, they must provide you with adequate compensation for that. And so that's similar to the issues explored in the movie The Castle, which is a very well-known Australian constitutional movie. The fourth right is the right to be tried by jury for indictable Commonwealth offences, which is outlined in section 80, and we know the benefits of that from the first area study of the course. And the right to not be discriminated against on the basis on which you reside, and that's outlined in section 117. So if you are a Victorian living in New South Wales, you can't be discriminated against because you are a Victorian and not born in New South Wales, for example. The express rights are very important because they outline clear limitations on Parliament, and they allow individuals to go to the High Court to challenge a law which is seen as violating our express rights. If the High Court believes that one of the 5 express rights has been infringed upon, they can declare that legislation ultra vires, which means it's invalid. The express rights can also only be removed by referendum, which means it's very difficult for Parliament to change them. And the only way that Parliament will be able to is by satisfying the double majority provision, which we will go through in a minute. Another strength is that the 5 rights have been the same since the Constitution was created, and so people are aware of them due to the stability of the rights. And that makes it more likely that people are going to enforce them if our rights were infringed upon. However, because we only have 5 rights and we have those rights can only be changed through referendum, it does make it very difficult if we were wanting to create some new rights in the Constitution and further protect our human rights. So the only way we could do that is through referendum, and as we'll talk about later on, referendums are quite hard to satisfy. Another point is that Parliament can actually make those laws, and those laws will be valid even if they infringe upon human rights, up until the point that someone with standing goes to the High Court and challenges those laws that infringe upon our rights, and the High Court declares them ultra vires. However, in order to go to the High Court and make a claim that our rights have been infringed upon, it's very expensive. The fourth check on Parliament is the High Court. So the jurisdiction of the High Court is outlined in section 75. The main role of the High Court is to act as a guardian of the Constitution. And what that means is that the High Court is responsible for interpreting the wording of the Constitution and ensure that it is complied with. As the High Court can interpret the meaning of the Constitution, it can change the wording of the Constitution to ensure that it is relevant to our 21st century society without actually changing the actual wording of the Constitution. So the wording and the sections of the Constitution remain unchanged. However, the court's interpretation and meaning of those sections will change over time. As we spoke about in relation to the express rights, the High Court also has a role to act as a check on abuses of power by government and Parliament. So individuals can bring a claim to the High Court if they believe that a piece of legislation is unconstitutional for whatever reason. Maybe it infringes upon our express rights, or it breaches the separation of powers or division of power. And the High Court can therefore declare it ultra vires and invalid. As we spoke about before, the judges of the High Court are independent from other branches of government, so that ensures that the decisions of the High Court are not affected by political grounds, and judges are willing to scrutinise the legislative and executive. Furthermore, the High Court judges are extremely specialised in constitutional law, and that just improves the quality of the decisions made by the High Court. However, the High Court's role is limited to the extent that judges can only rule on the constitutionality of legislation when it is brought before them. So they have to wait for an individual with standing and the financial capacity to bring a claim to the High Court. And once they have a case before them, they can only interpret the specific section of that case. If they believe there are any other issues that aren't related to the case, they cannot rule upon them. And as we spoke about before, the composition of the judges may affect the willingness of the court to interpret and change the meaning of legislation. And as we'll look at in the next area study, judicial activism is when judges are more progressive and willing to change the meaning of the Constitution over time, whereas judicial conservatism is when the judges are less willing to change that meaning over time and seek to keep the Constitution the way that it always has been. Finally, the double majority is the requirement to change the Constitution, and it's outlined in Section 128 of the Constitution. The double majority places power in the people rather than Parliament. And so in order to change the Constitution, either remove something from the Constitution, modify a section of the Constitution, or add something to the Constitution, we must have a referendum, which is a compulsory vote where every eligible voter in Australia will vote yes or no to a proposed question. The referendum must first be passed by both houses of Parliament, and then it must receive a yes vote from a majority of all eligible voters in Australia. And the second requirement is that it must receive a majority of voters in a majority of states in order for it to succeed. So that's the double majority. You need to get a majority of voters in Australia and a majority of states, which means that you need 4 out of 6 states to pass legislation. Once the double majority has been satisfied, the Governor-General then gives royal assent and it becomes law. Because the double majority provision outlines that second requirement for a majority of states to vote yes, it protects the smaller states. If we only had a majority of all Australians, then Victoria and New South Wales could make a majority of that vote without considering, Tasmania and the smaller states' views as well. It also ensures that the changes to the Constitution reflect the people's values and people's views, because it puts the power directly in our hands. And therefore, it prevents Parliament from changing the Constitution in a way that does not protect or reflect our interests. And so it upholds a significant limitation on government, because Parliament cannot change the Constitution in any way that it likes. However, the double majority provision is very difficult to achieve, and there have only ever been 8 out of 44 successful referendums. And so that may mean that necessary changes may be prevented. It's also a very expensive and timely process, with the most recent referendum costing over $100 million. And it's not suitable for urgent changes, because it does take a year or two to kind of set up and then hold the vote and pass it through Parliament prior. Also, it may appear undemocratic if a majority of voters vote yes, but not a majority of states, because true democracy is just 50% of the people. And that brings us to the end of the 7th video. And now we are up to the last video for Unit 4, Area Study 1. Hope to see you there. Thanks.